So an earnout is a tool that parties use to bridge a valuation gap between an optimistic seller and a very pessimistic buyer. So essentially, it's a provision in the definitive agreement that measures a company's performance post-closing and provides a seller an opportunity to obtain additional consideration based upon the performance of the company that they've sold. Typically, the parties will include a provision in the definitive agreement that provides a mechanism in which the seller of the business is permitted to receive additional consideration after closing based upon the future performance of the company being sold. This sounds fairly easy, and it can be if the target or the company being acquired will be a subsidiary or standalone subsidiary or a division of the buyer. However, it could get a little complicated when the target is actually merged into one of the businesses of the buyer. So the parties should be pretty careful about how they draft how this mechanism works. The parties should clearly define the financial metrics that will be used to calculate the earnout. The metrics can include the target's revenue, net income, EBITDA or earnings per share. The party should also clearly define which accounting methods they will be using in the calculation, whether it's GAAP or some other agreed upon accounting method. In the agreement, the parties should clearly define whether the payout will be over an installment period or whether there's a lump sum payment due. They should also agree upon whether there will be an overall cap on the amount that the seller is due in the earnout. The parties should also agree upon how long that earnout period will be. In the definitive agreement, the parties should agree how much control the seller will have post-closing on the business that they've sold and how much control the buyer will have. And this could have a significant impact on the seller's ability to actually earn part of the earnout. If the seller has absolutely no control, they're left up to the devices of the buyer and are relying on the buyer to perform and operate the company in the seller's best interest. And that could be a little bit difficult. It's always a good idea to think about how disputes will be resolved in the future. The parties should consider perhaps an arbitration provision and perhaps appointing an independent accountant to determine whether the parties are subject to an earnout payment or not. Earnouts can be a very helpful tool in an M&A transaction so long as the parties clearly define how it works and how long it will be in place.